Hello everyone, myself Prashant. Article 35. So this is the last article in part 3 of India's constitution, and part 3 is all about fundamental rights. So let's see this article in depth. So Article 35 says that power to make laws to give effect to certain specified fundamental rights shall vest only in parliament and not in state legislature. So basically, there are certain fields or certain categories or certain specified articles on which parliament can only make laws. State legislature don't have the authority to make laws on those subject or on those articles. Now, what are those subjects or rather articles on which only parliament can make laws or parliament has the authority to make laws? So first is Article 16, right? Article 16, in Article 16, where there is a residence as a condition for employment. So on this particular area, Parliament can only make laws. Article 16 is all about that there should not be discrimination when it comes to employment. So there are seven grounds mentioned in the Constitution. So those seven grounds are like religion, race, caste, sex, descent, place of birth, and residence. So here it talks about residence, right? When there is residence as a condition for employment. So in that case, only Parliament can make law. Then there is this Article 32. Article 32 is all about right to constitutional remedies, right? So here it says that when it comes to empower courts other than Supreme Court and High Court. So this statement means that there are certain writs in Article 32, like habeas corpus, certiorari, prohibition, quo warranto. So when it comes for the enforcement of those writs, or when it comes for the enforcement of any fundamental right, we know that Supreme Court and High Court have the power, but Parliament can make laws which specifies or which says that apart from Supreme Court and High Court, other courts can also have the power for the enforcement of writs or any fundamental right. So this is what Article 32 means. Here, Parliament has the power to give other courts the power for the enforcement of any writ. Now, let's move to the next slide and see other areas on which only Parliament can make laws. Article 34. Just give me a second. So, Article 34, where there is indemnifying government servants in martial law. So, we have seen in our previous video, or rather, learn about Article 34. So, when it comes to indemnify or compensate government servants in case of martial law, so on this subject or on this part also, Parliament only has the right, Parliament exclusive right to make laws. Parliament exclusive right, right? Exclusive right. Here, a state legislature or a state government can make a state government or a state legislature cannot make laws when it comes to indemnify government servants in martial law. Whatever acts the government servants does in martial law, so to compensate that, uh, there is this article 34, and on this particular thing or on this particular article, only Parliament can make laws, not a state government or a state legislature. Then the other article is Article 17, which is about untouchability. So on untouchability also, Parliament has exclusive right to make laws or make any changes to it. A state government or a state legislature don't have any right over it. Then there is this Article 23. So Article 23 is about prohibition of traffic in human beings and forced labor. So I'll have to write traffic in human beings, traffic in human beings and forced labor. So on Article 23 also, Parliament has exclusive right to make laws or make any changes to it. Then the last is any law shall continue to be law unless repealed or abrogated by Parliament. Very, very important. So whatever law is there in our country, that law will continue to be a law. It's not that if a new law has come on a particular subject, right? And on that particular subject already there was some other law in our country. Unless and until that older law is repealed or abrogated, the older law will also remain to be effective. It will be a law. There can be two law on the same subject, right? Unless and until one of them has been repealed or abrogated by the parliament. So if a law has to not be effective in our country, then that law needs to be repealed by parliament. Very, very important. Repealed. That law will have to be repealed to not be in effect. So this is what this means. So you should know this thing. Any law shall continue to be law unless repealed or abrogated by Parliament is under Article 35 of our Constitution. Very, very important, right? This is very, very important. Article 35. This comes in Article 35. So here we'll be wrapping our fundamental right section because we have covered all the articles from Article 12 to Article 35, right? All the fundamental rights have been covered. So thank you for your time. Thank you so much.